Anyway, guys, I'm not anti-government, but this proposal is just making me fume as a data privacy professional. And for those of you that know me well, will know how important it is for me that people are afforded these basic rights to their privacy. Anyway, so we saw this paper was published earlier this month by the DCMS. That's the Department for Culture, Media and Sports. And the reason it was published by the Department for Culture, Media and Sport is because they're also the Department for Digital, right? And what that means is they have a remit over privacy legislation because a lot of it is to do with technology. A lot of it is to do with being digital. So what happens is they said, look, we want data protection laws in the UK to change. We're no longer part of the European Union. We've had Brexit, woo, according to them, right? I think Brexit was a bad idea, but anyway, they said, look, we've had Brexit. We are no longer bound to follow the European law, so we're going to make our own data protection laws up. And here's some proposals that's going to help the economy to actually prosper. And what they believe is these changes that they're suggesting, once these changes are implemented, they're going to help British businesses and it's going to help to grow the economy. So they published a 146-page document talking about these proposals. And nobody's got time to go through a 146-page document. So I've actually taken the trouble, myself and my team, and we've taken all that information and we've made it very easy and we've put together a summary. So on the 10th of September 2021, the government published a document that makes suggestions for changes to UK data protection and privacy laws. Now, it affects a number of laws. So first of all, it affects the UK GDPR, the Data Protection Act 2018, DPA. But it also impacts what we would call a PECA. So PECA is the Privacy and Electronic Communications Regulations. And the government wants to improve UK data protection laws. They believe the changes is going to help the economy to grow. So here they've got 5 key goals that they talk about. So number 1 is they want to promote ideas which are going to help the economy to grow. And the suggestions on how they're going to do that is number 1, they said they're going to make clearer rules on when and how to use personal data. They want to make it easier to use personal data for research purposes. They want to make it clear when personal data can be used for another reason. So we're talking about secondary use now. They want to reduce the need for an individual's permission to do things with their personal data. So the government's saying people should no longer have to give consent. An organization should be able to do whatever they want with your data, whether you consent to it or not. They want to make sure that artificial intelligence and machine learning tools are made with trust, so they are used fairly, without bias and discrimination. And any of you that have studied artificial intelligence will know that it's ridden with bias, especially against people from a black and minority ethnic background. And they want to make sure that personal data is collected, that is collected is suitable, relevant, and used only for the reasons it was collected for. And they want to encourage people to come up with new ways of using and sharing data. So I don't know what you guys think about that, but when I look at this as a privacy professional, I'm absolutely outraged that the government thinks that British people should have less rights over their personal information than people living in Europe, right? Britain says we pride ourselves on our rule of law, and therefore diminishing the rule of law and taking away people's rights and civil liberties and eroding what we enjoy already, I think that's absolutely disgraceful. I see no benefits to the economy of actually helping people or stopping people from having to consent, from giving permission, right? People should have the right to decide how their data is used or not used. Nobody should say, I'm going to take your data and use it the way I want to, and I don't care what you have to say about that. That's pretty much what the government's saying that big businesses, tech companies can do. And we see there's such a big shift in the public opinion of what is actually happening with people's data, that companies like Apple, they know now that they don't have to talk about how great their camera is or how fast their chip is. All they have to do when they release the new phone to get people to spend more than £1,000 to buy it is say, hey, this phone is going to help you to protect your privacy, right? Now, whether it is or not is a completely different matter. But what we can see is even companies like Amazon are saying, hey, we value your privacy, come here. But on the other hand, we can see they're actually all getting fined for not respecting people's privacy. So that's the first suggestion, to promote and help the economy to grow. And as you can tell, I'm not a big fan. So number two, they say, is we want to reduce the burden on businesses and protect the rights of individuals. And the suggestions to make this happen include bring about a data privacy management program to help organizations to follow the law. So look, if they can bring in place a standardized framework, that's great. The problem is, I can tell you, having implemented data privacy frameworks for similar businesses across 6 continents, no two businesses are the same, and putting in place a rigid framework might work for one industry and one organization, but it's definitely not going to work across the board. So I'm not sure if that's such a great idea. They want to remove the need for a data protection officer and instead have an individual or a group of individuals to look after data protection observance within an organization. So look, a lot of organizations struggle with holding themselves accountable even though they've appointed a data protection officer. By removing the requirement to appoint a data protection officer, it's going to mean that people are going to hold themselves even less accountable and there'll be less resources allocated to it. If a company knows, if the board knows they don't have to appoint a data protection officer, they're most likely going to want to make cost savings. They're going to axe that budget. And therefore, that resource, that accountability, that additional support that the business had to help them with their privacy is going to disappear. And that's bad news for British businesses, because if you're a European person, or even if you're a British person, if you're a person anywhere in the world and you know that, hang on a minute, in Europe, if I give them my personal data, when I buy something from a European business, when I go on a European website, my data is going to be looked after better, rather than the UK, where they watered down the data protection laws. Who are you going to go and spend your money with? Now, there was a study that was done, and it was published by the IAPP, and they say that 63% of people think about the privacy and protection of their personal information when making a purchase online over the quality of the product, or over the specification of the product. What that means is people are going to spend the same amount of money to get a lower let's just take the example of a laptop. You've got two businesses selling the same laptop. One business is selling it for X amount, another business is selling it for the same price, but it's a lower spec. But people are more comfortable and confident that these guys are going to look after their personal data more. They're more likely to buy that product even though they get less for the money, because they feel more comfortable about their personal data. So what we're saying is, if these proposals come into force, then it's bad news for British businesses unless they say we're not going to follow the government's proposals and we're going to continue to follow the European GDPR, because they want to make sure that they have people's confidence and trust when they take on their personal data. All right, so they want to remove the need to carry out a data protection impact assessment. So a data protection impact assessment is something that we carry out whenever a business starts collecting information and processing it in a new way, or changes the way they're doing something which has a high risk to the rights and freedoms of an individual over their personal data. And what we do with the data protection impact assessment is try and find what those risks are, and then we remove them by mitigating them and putting things in place. So the government's proposal here is to say, hey, you don't have to worry about what the risks to personal data are. Do whatever you want. If something goes wrong, so be it. So again, I think that is another utterly ridiculous proposal from the government. Next is remove the need to inform the supervisory authority when there's a high chance that using people's personal data a certain way could bring people harm. That's absolutely ridiculous. If somebody's got hold of my credit card details, if somebody's got hold of your credit card details, you would want the business that's had that data breach to let you know, so you can go and call the bank and block the card and do whatever you need to do, right? The government is saying here now, hey, if something happens with someone's personal data while you've got it, even if it's going to cause them problems and harm, don't worry about it. This is absolutely ridiculous. Like, this is actually making me so angry. I can't even tell you how ridiculous this is. All right, next they say, remove the need to have records of processing activities. That is just the stupidest thing I've ever heard in my career as a privacy professional. A record of processing activities is what every single organization relies on to understand what's going on with their business with personal data, right? So if you don't, let's say you're planning to go on a journey and you want to go somewhere you've never been before. You're going to want a map, and the map shows you all the roads which will take you there, all of the things along the route, so ultimately you can plan your map. A record of processing activity is a little bit like a map. It's a map of all of the data and where it flows and where it's going out to and where it's coming from and who it's being collected from and where it's stored. If you don't have that information in your organization and you're collecting and processing personal data, God help you. Now, this irresponsible proposal from the government is suggesting that companies do away with that, and there is no need for you to understand what your processing activities are, what personal data you're collecting, how long you're collecting it for, who you're going to share it with, where you're storing it, or any of that information that we expect to see in a record of processing activities. So that's bonkers again. All right, so Liz Diaz says, the lack of a DPIA seems nuts to me, but as I'm sure you'll come on to see incongruous with the latest suggestion of risk-based decision making, don't think they understand what a DPIA is. I don't think they understand what any of this is, Liz, and I think this was just an attempt to score some points politically and woo some businesses to say, hey, Brexit was great for us, you can now come here and do business, you don't have to spend as much money on data protection, and they think that's going to attract businesses. But what smart businesses, what smart seaboard people will know is that actually data privacy can be used as a competitive advantage, and if we can get that right, we can inspire trust, we can cultivate confidence, and ultimately it's going to mean that we can secure more business or make more of an impact. So yeah, that's the next thing they say is let's get rid of records of processing activities. Then they come on to say, agreed, yeah, thank you, Liz. Next, they come on to say, make people pay if they want to learn about the personal data organizations hold about them. So right now, because we were part of Europe and because we have the GDPR in force, it means that everybody has the right to enforce or seek to exercise their privacy rights without having to pay any money. This government is proposing for you now to exercise your basic human right to privacy, you have to pay for the privilege. How do you guys feel about that? Do you think you have to pay for the privilege of being afforded your basic human right to privacy? I think that's absolutely bonkers. What do you think? Let me know what you think in the comments, guys. All right. Next, they say, let analytics, cookies, and similar technologies be used without people's permission. Man, people are already fed up that every time they're having a private conversation with someone, every time they're talking about something, they pick their phone up and the next thing they see is adverts about the thing they were talking about. Now, this government is proposing that things like that should continue to happen, and you don't have a say in whether that's allowed to happen or not. You don't have a say whether somebody can spy on everything that you're doing with your device, where you're shopping, what articles you're reading, what kind of things you're interacting with on social media. That government says here, you have no right to object to that or to have a choice about that. They're saying, look, organizations should be able to do that. Why do you care? Why should you have a problem with it? Again, I think that is absolutely insane. And then they go on to say, increase the amount organizations can be fined under PECA to match the GDPR. So look, this is not something that the government's coming up with. We can see under the e-privacy directive that is being talked about by the European Data Protection Board and other people in Europe, that they're talking about bringing e-privacy laws and fines in line with GDPR anyway. So that is a bit of a redundant point because we're looking forward to that already. All right, so that's point number 2. So point number 2, again, just to remind you, was they say it was to reduce the burden on businesses and protect the rights of individuals. So Liz says the thing that there is already a cookie notice, shake up on the cards, this is riding on the tails of work already in place. Exactly, this government is trying to take credit for things that are already happening. And it was actually this government who was trying to block those things from happening to begin with. This government was putting up the resistance to having those things in place for the cookie notices and the other e-privacy stuff. So I actually have no idea how they can publish this document and have any sense of shame whatsoever. All right. Anyway, guys, I'm not anti-government, but this proposal is just making me fume as a data privacy professional. And for those of you that know me well, will know how important it is for me that people are afforded these basic rights to their privacy. Anyway, number three, third proposal, or the third big thing they say, is they want to boost trade and reduce data transfer requirements. Okay, and the suggestions to make this happen is number one, make sure personal data is protected before it leaves the UK. Okay, that's excellent, that's great. Add more countries to the list of countries considered safe to send personal data to without any extra protection. Well, I'm not sure I'm comfortable with that, because if the European Union don't believe these countries are adequate, why should we accept that they're adequate for British people's data to be sent to? I'm not comfortable with that, and I don't think anyone else should be either. Why should we be afforded less protection than our European counterparts? It doesn't make any sense to me. Does it make sense to you guys? Let me know. What do you think? Okay, so that's the first thing. Then they say, introduced risk-based decision making and outcomes to decide how safe a country is to send personal data to. I actually like that. I think that is a great suggestion. We should have a risk-based decision making when it comes to doing stuff. And that's why we do data transfer impact assessments already, right? We're already doing that. We're already taking a risk-based approach. This is not a new suggestion. Then they're saying, remove the need to check whether a country should stay safe on the safe list every 4 years. So for those of you that are familiar with the GDPR, you know there is an adequacy list. And that adequacy list says anyone that's on the adequacy list is subject to a review every 4 years. It's not that, yes, you're on the list now and you're going to stay there forever. You have to make sure that your level of privacy, your government's implementation of privacy in that country remains at an acceptable level to stay on that. This government is saying, look, if the country is good enough, put them on there and let them stay on there for life, regardless of what happens, what regime changes there are, what new laws there are, what new practices come into that country. Forget that. Okay, so again, this is unacceptable. They say future-proof the rules and guidelines to protect personal data before it's sent outside the UK. Okay, that's fine. That's actually a good suggestion. Future-proof the rules and guidelines. How are we going to do that? Explain that to us. It's all very well saying it, but we need to see some actual pragmatic solutions on how you're going to do that. They say allow organizations to be more flexible over how they protect personal data when sending it outside the UK to a country that is not on the safe list. So again, that sounds like a pragmatic proposal being put in place, and that actually makes sense. There should be a little bit more freedom and a little bit more flexibility with how an organization or data controller is able to send data outside of the UK. But that doesn't mean that they should be able to afford less protection to that data. It just means give them a bit more flexibility. Now, if the proposal suggests, or if the proposal turns out to be, hey, protect it in a way that is less guarded, then obviously we're going to have a problem with that. All right, so that's the third thing. That was about boosting trade and reducing data transfer requirements. Number 4. The fourth thing they say is change duties and objectives to the Information Commissioner's Office. And the suggestions for making this happen is new guidelines describing the goals of the ICO when doing its job, new objectives for the ICO to promote the individual's rights and to encourage personal data to be used in ways that are trustworthy and responsible. Well, I thought that was the ICO's job anyway. Appoint an independent board and a chief executive officer of the ICO. Okay, so you want to add a little bit more bureaucracy. I see no benefits in doing that, but okay. Let's hear your arguments why. Get the ICO to cooperate and talk with other regulators. I think that's a great thing. I think the regulators should actually spend more time cooperating. So this is something that I actually support. And the ICO should publish key performance indicators. I absolutely agree. The ICO should publish key performance indicators and demonstrate to the public how well they are spending their money. Because right now, the ICO is a laughing stock. When I'm talking to my European counterparts and they hear I've got a consultant or I'm based in the UK, they have a good laugh because the ICO does a very poor job of enforcing the GDPR. Over the last 3 years, they've issued 3 fines, 2 of which were reduced by around 90%. So, based on their own record, they're actually doing a pretty poor job. So, I welcome key performance indicators to see how the public's money is being spent by the ICO. Make individuals sort out their complaints with the organization themselves before they're allowed to complain to the ICO. That's absolutely ridiculous. If someone's got a conflict, if someone's unhappy with the way the personal data is being processed, if an organization is not giving them their rights, why would you want individuals to have the burden of dealing with those things when you're there as an independent and impartial regulator and our tax money actually goes towards funding what the ICO does? No, we don't want to try and sort it out ourselves. We want to complain to the ICO and we want the ICO to sort it out. Not that they're doing much of that right now, but we are not for allowing this kind of a proposal to be accepted. And the other thing is, what this is suggesting is that the ICO, what's supposed to be an independent and impartial body, is now actually following policy. And we can't accept that. We can't accept that because for there to be a good rule of law in a country, there needs to be the separation of powers. So you need to have the executive, the legislature, and the judiciary. They all need to be separate. Now, the ICO, as a judiciary, as the independent regulator, they can't have the executive telling them what to do and how to discharge their duty. Because when that happens, when there is no independence in a country, you get what is known as tyranny. And this country is known for invading other countries for saying they have tyranny and they're run by tyrants. So we cannot accept tyranny of the ICO in the United Kingdom. All right, and then they make a few other suggestions as well. So they want to create a list of legitimate interests for which organizations can use personal data without having to do a balancing test. Again, I'm not sure how they're going to come up with an exhaustive list of that. It doesn't make any sense to me whatsoever. They want to take away the individual's right to object when the personal data is used by a computer to make a decision that's going to have an important consequence to them. Again, that is absolutely ridiculous. Why would you erode people's rights in such a way? It is absolutely irresponsible. And the final thing they say is they want to create a standard or a certification for some kind of a peacemaker to help with personal data problems between two parties. So they're talking about some kind of arbitrator of data protection challenges. So that actually is an interesting suggestion. And I would like to see how they go about doing that. Now, the most important thing to understand here is the guy, the cabinet member who published this proposal, he was sacked a few days later, right? So I'm hoping that's good news and people have been just as outraged as me by these ridiculous proposals, and therefore this guy has been sacked. So I'm hopeful that none of these proposals, apart from one or two of the really good ones, see the light of day, and we will be putting in our feedback for the consultation. And of course, this is open to consultation for the public, so I encourage all of you guys to read through the summary, and if you have the time and if you have the interest, read through the actual document and put together an email or a letter and let the government know exactly how you feel about that.